Assalamualaikum warahmatullahi wabarakatuh. Our group will present a presentation for tourism and hospitality law for Hajj and Umrah subject. This slide was prepared by Hazmi Khairuddin, Nurul Anwar, Aiman Farhan, Badrul Hisham, Shafirul Aiman and Muhammad Lukman. And this slide prepared for Miss Nadirah Abdul Rahman as our subject lecturer. Without wasting time, I invite our first presenter, Aiman Farhan, to answer the first question.
Assalamualaikum warahmatullahi wabarakatuh. Question number 1 is a contract is an agreement between two more parties that is legally enforceable. Legally enforceable when one party fail to perform his side of the bargain. He is said to have breached the contract and the other party and bring an action in action. According the statement above, explain the element of a contract. You may refer any relevant provision from contract X and case law. Okay, the answer is okay. The element of the contract number 1 is offer. An offer is a person willingness to do something or abstain from doing something. An offer can be made orally or in writing. There are two types of offer. First, unilateral offer and bilateral offer. Second element of the contracts is acceptance. Acceptance when offerance acceptance as offer he said to have made now by words or conduct that he agrees to the terms of an offer. And acceptance must be absolute and unqualified. It is match the terms of the offer. There is a acceptance if an offerer introduces his own terms or qualifies his acceptance with a modifier such response that modify and offer a counter offer. The next element of the contract is consideration. Consideration is value for a promise. It needs to be quantified in terms of money. Past consideration is good. Consideration can move from a third party. Consideration need to be adequate. Payment of a smaller sum sufficient consideration to discharge a larger sum. Then the next element of the contract is intention to be create legal relation. Intention to create legal relation is means a person intention to be legally bound by an agreement. As a general rule, domestic agreement those entered into between spouse, sibling, relative are not considered legally binding non-notarious. There is a contract there is a contract in the following. First is Balfour v. Balfour 1919 and second is Merit v. Merit 1970. Commercially agreement are generally presumed to be legally binding. Such presumption rebutable. The last element of the contract is capacity to contract. Minor under 18 years old and person of unsolved mean lack the capacity of contract. However, a minor can contract for necessaries thing or service suite to the minors condition or life at the time of sale delivery. Education, training, and employment contract entered into by young person, children, and young person. Consideration necessaries. Okay, next.
Pass to Nuril Anwar.
Okay. Assalamualaikum warahmatullahi wabarakatuh. My name is Nuril Anwar bin Muhammad Abdul Munaf. I would like to answer the question of this question. The question is, Ali, a 16 years old boy, saw an advertisement by Amazing Tours in the newspaper. Fabulous deal. Bali from 999 ringgit for two. Call 014-669-1882 to make your reservation now. When Ali called, he was told that the tour package were all sold out. Ali insisted that Amazing Tours honor their promise. Discuss whether Ali can insist on purchasing the tour package. Okay, for the answer of this question is, according to of contract, voidable contract and void agreements, who are competent to contract is every person is competent to the law with he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. In this case, the Amazing Tours no need to fulfill their promise because Ali is 16 years old boy. Incapacity to contract, minors that under 18 years old people and persons of unsound mind lack the capacity to contract. However, a minor can contract for necessaries, things of or service suit to the minor's condition of life at the time of sale of delivery. It refers from Nash v. Inman, 1908. Education, training and employment contract entered into by young persons with children and young persons employment. Act 1966 are considered necessary. Okay, however, an offer must be clear and definite. Amazing Tours doesn't mention that the fabulous deal is limited to the allocated participants. An offer is different and shall be distinguished from three elements. First, invitation to trade. Second, request for information. And last is supply of information. Most online promotions are considered invitation to trade. However, a contract can be concluded online, where a person responds to online product advertised. Revocation of offer. This is a withdrawal of an offer. An offerer who changes his mind can revoke his offer provided that it has not been accepted by the offeree. Okay, thank you. That's all from me. I will pass the next question to Lukman.
Hai, Assalamualaikum warahmatullahi wabarakatuh, and good evening, good morning, and good another morning lah. So I would like to answer this question. Question number 2. Question is, Farah agreed to sell a brand new BMW car worth 500,000 ringgit to Saiful with 30,000. However, Saiful responded to Farah by offering a reduced price for said car. Discuss, was there any contract between Farah and Saiful? Okay, before the answer, I would like to explain 2 about contract. About contract lah. First, a unilateral contract is one in which there is a promise to pay or give other consideration in return for actual performance. Example, I will pay you 500 ringgit to fix my car by Thursday. And the performance is fixing the car by the date, by date. And second is a bilateral contract. Bilateral contract is one in which a promise is exchanged for a promise. That means, for example, I promise to I promise to fix your car by Thursday, and you promise to pay 500 ringgit on Thursday. So the same day they pay, and the foreman is fix that car. Okay. So based on this situation, this situation given, there is no contract between Farah and Saiful because there is an offer but don't have any acceptance neither from Farah or Saiful. But it's also have a possibility to have a contract if suddenly one of them change their mind. It may be either Farah accept the offer provided by Saiful or Saiful agree to accept the offer from Farah. Alright, thank you. That's all my answer. So we go to next question. Question number 3 for this. I give to Muhammad Hazmi Khairuddin. Thank you.
Okay, technician problem.
Alright.
Ada?
Yeah. I can hear you.
Okay. Assalamualaikum. My name is Muhammad Azmi Khairuddin Yusof. So the question is minor lack capacity to contract. This phrase mean? What does this phrase mean? Okay. Explain and give example by referring to the Age of Majority Act 1971 and the contract at 1950. So the answer is next. So the answer is according to this act, the age of majority is 18 years old. So that below than 18 years old is considered as minor. The age of majority should be not confused with the other types of age. For example, voting age, marriageable age, age of consent, legal working age, school living age, legal driving age, smoking age, legal drinking age, age of criminal responsibility, age of candidacy for political official, and other more. Because a different age is set for this type of age. Is at short effect. For the first is the capacity of any person to act in the following matters, namely marriage, divorce, dower, and adoption. So the second is the release.
Azmi, are you okay?
Cakap. Cakap.
Technical problem. Excuse me, excuse.
Hello, kat mana saya tadi?
Nombor tu
Different age is set for this type.
different.
Ah,
Okay, so the second is the religious right and usage of any class of person within Malaysia. So the last is any provision in any other written law contained within the age of majority for the purposes of the written law. So that's all for me. So I pass to Muhammad Syafri Rahman maybe or Aiman.
Badrul Syam.
Me,
Syafri Rahman.
Badrul.
Okay.
Badrul Syam.
Badrul Syam, sorry. My bad.
So I go through to question number 2 is no others. Question A. So
Attention.
negligency is the causing of harm to another person through an act or an omission, which is a failure to do something. In other, to prove the existence of negligency, a plaintiff need to prove the element in order to establish negligency. So discuss what are what are the elements to establish negligency by referring to the relevant provision and case law. So the answer is, I will explain about negligency first. So negligency is when someone to fail to carry out certain standard of conduct. For example, an individual does not carry out an act which reasonably careful person would or does do something which a reasonably careful person would not do, causing harm or loss to another individual. So, one to element to establish negligency is there are 4 key elements in proving negligency. An element is necessary component of a legal claim. The plaintiff must prove the following to prove negligency, such as duty of care, breach of duty, causation, and remoteness of damage. So the first element is duty of care. Duty of care means that defendant was under obligation to be careful toward the plaintiff. There are situations where a legal duty is created in the relationship between the plaintiff and the defendant. A duty of care arises when the law recognizes a relationship between two parties. And due to this relationship, one party has an obligation to exercise same level of reasonable care that another person in a similar situation would exercise. Example, duty of care. All taxi drivers are expected to maintain their vehicle in safe condition and operate their vehicle safely and in accordance with all traffic law. So, business owner have a duty take reasonable care to ensure their premises are safe for their customer and employees. This can include regularly inspecting their property for hazardous condition and fit it within a reasonable time frame. So the second element is breach of duty. Breach of duty in negligence liability may be found to exist where the defendant failed to meet the standard of care required by law. Once it has been established that defendant owed the claimant a duty of care, the claimant must also demonstrate that the defendant was in breach of duty. The test of breach of duty is generally objective. However, there may be slight variation to this. So, for example, in this Nestle ship v Western 1971 case, the defendant was a learner driver she was taking lesson from a friend. The friend checked that the defendant insurance cover her for passengers before agree to go out with her. On on one of the lesson, Mr. Weston turned a bend, and Mr. Nestle Ship told her to straight the wheel, but Mr. Weston panic, and failed to straight the wheel. She approached the pavement, and Mr. Nestle Ship grabbed the handbrake and tried to straight the wheel, but it was too late. She mounted the pavement and hit a lamppost. So dia langgar dengan tiang lampu. Mr. 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 Nestle Ship fractured his knee. The defendant argued that the standard of care should be lower for learner driver, and she also raised the defense of voluntary non-fit injury in agreed to get in the car knowing she was a learner. He had voluntarily accept the risk. So dia masih study lagi lah. So dia anggap, dia terima lah risk tu. So the third element to establish negligence is causation. Causation require a plaintiff to show that the defendant breach of duty was the cause of the plaintiff injury and loss. Another thing to consider is whether the defendant could have foreseen that his or her action might cause an injury. If the action caused the plaintiff injury through an expected act of nature, then it would be deemed unforeseeable, most likely making the defendant to be found not liable. So, for example, the supervisor of grocery store sees an employer drop Grab in the produce aisle. Neither the supervisor nor any other employee clean up the Grab promptly, and elderly customers step and slip on the grape. So dia pijak anggur tu. A broken hip is reasonably related to their breach of the duty of care, because if the store employee had picked up the grape, the customer would not have slipped and fallen on the floor. So kalau dia employee dia pick up grape, dia takkan berlaku lah. So the final element is remoteness of damage. Remoteness of damage related to the requirement that the damage must be of a foreseeable type. In negligence claims, once the claimant has established that defendant owes them a duty of care and is in breach of that duty which has caused damage, they must also demonstrate that damage was not too remote. For example, in this case, Repolymis and Furnace Witty company case, some stevedores carelessly dropped a plank of wood into the hull of a ship. The plank struck something as it was falling, which caused a spark. The spark was ignited by petrol vapor, resulting in the destruction of the ship. The arbitrator held that the causing of the spark could not have been anticipated, and therefore no liability arose. The claimant appealed. So here, there was no requirement that the damage was foreseeable. The defendant was liable for all the direct consequences of their action. So thank you. That's all for me. I pass to Shafir Aiman.
wabarakatuh. And are you ready? Okay, my name is Muhammad Shafirul Aiman bin Salim Alizal. So I want to give the answer to the last question. So the question is Eden Garden liable to Julie? So the answer is yes. Eden Garden are responsible for Julie. It is because of an employee who performed his job in an improper manner may be considered to have performed an authority act in an unauthority way. Limpus v. London General Omnibus 1862, Beard v. London General Omnibus 1900, Rose v. Plenty 1970. It is referred to Rumi's action are not informed about the beef condition, which is the beef has already bad and unpleasant smell, and also causing Julie to suffer of food poisoning. Okay, for the next question is Eden Garden label Julie? So the answer is yes. Eden Garden are responsible fully. It is referred to the careless act done while an employee is doing tasks related to his job. Is considered to have occurred in the course of employment. Century Insurance for Ltd v. Northern Ireland Road Transport Board 1942, Compton v. Mekla 1975 NL. In that situation, Rumi did not grip the handle of the pot properly and spilled the soap into Lee. It is referred to the vicarious liability deals with situation in which an individual has committed a tortoise act twice, acting on behalf of another. Two primary situations in which the concept will arise is one in which someone is acting on behalf of an employer. An explanation for this phenomenon can be seen in Dubai Aluminium for Ltd v. Salam 2002 3WLR 1913 per lot nickel. The underlying legal policy is based on the recognition that carrying on a business enterprise necessarily involves risk to others. It is involved to the risk that others will be harmed by wrongful act committed by the agent through whom the business is carried on. When those is slipped into loose, it is just that the business should be responsible for the compensating to the person who has been wronged. If a third whereas in column a negligent party inflict injury on a victim and the ultimate harm it was that what would normally be expected because the victim was more vulnerable due to some pre-existing injury, then the third person is still responsible for the whole harm suffered. This is referred to as the actual skin rule. Actual skin rule. For this famous rule of tort law can be traced back to the case of Postcard V partner 30 NW403. You take your victim as you find him. Okay, however, the defendant may be excused from liability if they can show the harm suffered would have happened anyway from the pre-existing condition regardless of whether the thought happened or not. A thought is a legal term that means a wrongful act or omission leading to legal liability. The basic principle of the actual rule is the defendant in a civil case must take full responsibility for all the damage that they cannot do to the victim, regardless of the fact that the particular more susceptible than a normal person may have been. This is a very important rule when it comes to personal injury claim, and it shows up all the time in car wreck cases. For example, if an older person is rear-ended while sitting at a red light, and they suffer a broken back because they have breakbone, tulang dia rosak lah, tulang dia tak berapa kuat. Whereas a younger person may only have suffer soft tissue dia koyak. Injury in the exact same situation, the person who hit them is still responsible for the full extent of the damage they caused. So that's all from our answer for this assignment law. So thank you and bye.